say I am sorry for the loss of your son. I did not know how old he was. I thought he was a little bit younger than I am, and I did not know if he was armed or not.
There you have it. Stunning so many. George Zimmerman taking the stand. George Zimmerman in suit and shackles apologizing to Trayvon Martin's mom and dad who were in court. And we're hearing they were so emotional as they heard that. Welcome, everyone. You're watching HLN. I'm Mike Galanos. Now, George Zimmerman, we know he won't be walking out of jail today as bond is set at $150,000. And there's a host of conditions concerning that. Among them, GPS monitoring to make sure everybody knows where he is at all times. Bond set at $150,000. So that means a 10% payment, 15 grand, and he is out. But again, he's not going to get out today because they have to work things out. You have to do this in secrecy and in safety for George Zimmerman and those around him because of all the emotions running so high on this. I want to welcome back Mark Eiglarsh, a criminal defense attorney, providing expert analysis. He knows the Florida law so well and has been watching this with me and you for the last hour. Also with us, attorney Brian Claypool. Brian, it's our first chance to talk since all that went down. Zimmerman talking, bond set at $150,000. Let's get your reaction first. Zimmerman taking the stand. How risky was that?
Well, Mike, first of all, I think Mr. O'Mara did a good job of actually putting Zimmerman on the stand, humanizing him, exposing him to the community so that he can portray a person that is compassionate, works with kids, he's not violent. So I think it was a risk, but it was a risk that paid off.
Okay, and then you have, and we just heard from the attorneys for Trayvon Martin's mom and dad, basically they're calling this a self-serving apology, and they're devastated that bond is set and George Zimmerman gets bond 9 days after the arrest. Could this be perceived as self-serving?
Here's the problem I have this morning. What was the state attorney doing as far as allowing this extensive hearing to take place? If I was the state attorney, I would have tried to preempt this hearing because this turned into a dog and pony show for George Zimmerman. I would have tried to work out a stipulated amount of bond for Mr. Zimmerman because we know that he was going to be issued, granted bond today. I would have tried to work something out, have an agreement, and avoid all of this testimony today. I'm very surprised at the state attorney in allowing this to go forward, and I would have been objecting to most of the testimony elicited today. This was like a mini jury trial.
What specifically would you have objected to as this played out?
Well, first of all, whether Mr. Zimmerman is sorry or not, I don't think goes to the issue of whether he should be granted bond and how much bond. Also, the evidence that was discussed today, that's not relevant in a bond hearing. The key factor in a bond hearing is Zimmerman a flight risk? That's what we all know he was going to be granted bond.
Right. All right.
So I'm really stunned at the scope of this hearing this morning, and it should have been preempted by the state attorney.
Let's get Mark's take on that. You're right there in Florida. Do you agree with that Mark O'Mara was given way too much latitude and the state attorney should have shut some of this down?
No. In fact, I disagree with your other guest respectfully. One of the issues is whether he's a risk of flight. If there's a busload of nuns, a videotape, a confession with graphic facts where he's got absolutely no defense, he's more likely to flee. The facts become relevant in this case to show the judge not only does he have he's got a chance of actually winning this thing, and those facts are very, very relevant then for the judge to determine whether he's going to return back to court. So I think courts generally give some latitude. In fact, it's in the statutes to consider the evidence and how overwhelming it is in determining whether a bond is appropriate.
All right, Mark, let's go. Because what Mark O'Mara did, from my humble vantage point, is he began to pick apart this two-page affidavit, probable cause affidavit, co-written by the investigator we heard from, Dale Gilbreth. Among the things he went after, he picked out words like, why'd you use the word profiling? He even went, okay, peanut butter and blank, Mo Larry and blank. What was it? Profiling. What goes with that? What was he going for there, Mark? He was trying to get him to say, what, racial profiling or criminal profiling?
I think overall, he was trying to show that many conclusions were drawn without the supporting evidence. For example, they made the conclusion that Zimmerman continued to follow Trayvon Martin in spite of the 911 call. So then he questioned him. Okay, well, what evidence do you have? Well, there was someone who saw some shadows of figures. Well, do you know who those people were? No. Do you know what direction they were going? No. So those shadows could have been consistent with anybody. In other words, the evidence what O'Mara was trying to raise was either scant or non-existent to come up with those significant conclusions.
Okay, so to Brian's point, should the state have been ready for that? And once it went down, could they have done something to object and shut it down? Or should they have been more prepared to answer those where he went?
First of all, this wasn't their first Arthur hearing. I've done a ton of them, and everybody knows that evidence gets discussed. So these prosecutors knew there would be cross-examination of the evidence. Number two, they tried to shut it down to some extent. The judge allowed some leeway. Three, it is relevant. They did everything they could. Both sides, I think, did a phenomenal job. What came out was relevant. Some not so much. His apology to the family, no. But the judge didn't know what he was going to say. The defense questioned the defendant. He came out with that, and then it was out. And then the judge, candidly, I don't think relied at all on his apology to determine what the appropriate bond was.
Okay, Brian, let's get you back in on this. Again, you're critical of the state here for not doing more as you said, this turned into a dog and pony show. The state should have stopped it. What do you suggest? What should they have done in retrospect?
What they should have done is they should have contacted Mr. O'Mara before this hearing, and they should have engaged in negotiations to create what's called a stipulation, which is an agreement by lawyers that they submit to the court that the court then signs off on. Because if I'm in the state attorney's shoes, I know that this judge is going to grant bond, right? So get together with the other side. Hey, what do you think the amount should be? $250,000, $500,000. Let's have an agreement, submit it to the judge. He signs off on it. You obviate the need for this hearing altogether today. That's what I would have done if I was the state attorney.
That presupposes, wait a second, that presupposes those discussions didn't happen, number one. And number two, they were so far apart, one wanting $1 million, one wanting $15,000, that if those discussions happened, they didn't prove fruitful. There was no way that they were going to stipulate to a $250,000 bond, which would have been tantamount to no bond because Zimmerman does not have those financial means.
Got it. Hey, let me point.
Mark,
go ahead. You want to respond, Brian?
You proved my point. If somebody's at $15,000, somebody's at $1 million, they'll meet in the middle at $500,000. You submit it to the court. It's only $50,000 that Zimmerman's got to come up with. The court signs off on it.
And $500,000
and this hearing doesn't go forward.
Brian, he can't make a $500,000 bond. I disagree with you.
Okay.
I think the defense should have done this hearing, and I think the prosecutors did the best they could at their level of awareness during the hearing.
All right. Let's take a quick break, guys. Good back and forth as we try to gather an understanding of all this. Again, you're watching HLN in our continuing coverage. There's George Zimmerman shaking hands with the shackles. Suit and shackles, he takes the stand. And I saw him smile afterwards as that $150,000 bond was announced. He will be reunited with his family shortly. We're going to have much more, and we will hear from Trayvon Martin's parents' attorney. He says the family's devastated. More coming up.
Deadly force.
Okay. Brian, let's talk a little bit more about the state. And again, I agree with Mark. I thought it was very effective to the point where I could just jot down words like that. And here's where they're going. And this is what they want potential jurors to hear, that Trayvon was an innocent kid. He was followed. Trayvon Martin was scared. He was pursued, and so forth. So to that point, do you think the state did a good job?
Look, I'm not disagreeing with Mark that both these lawyers did a good job. That's not the point. I don't think this was the appropriate forum to be putting on these issues this morning. They were litigating evidence in the case unrelated to whether this judge should have issued a bond here. That's my first point. Second point is, if I was the state, I would have argued that those vertical marks on the back of Zimmerman's head are more consistent with a self-defense gesture on Trayvon Martin's part. If you smash somebody's head in the back on cement, you're going to have a round oval-shaped bruise. You're not going to have vertical marks on the back of the head. Probably consistent with Trayvon Martin defending. He's throwing his hands up to defend. He scratches possibly the back of Zimmerman's head. Nobody's brought that up. I think that's an issue to bring up. Also, where's the DNA in this case? Well, we'll find out later, but hopefully there was some DNA taken from Trayvon, and that should have been matched to that wound in the back of Zimmerman's head.
And Mark, to Brian's point there, I mean, we're not, and Bernie Della Rianda said that. I didn't know we're trying this case here today. He said that, referenced that a couple of times. They have more than what we're seeing, and what we're seeing here in this two-page affidavit.
Absolutely. Let's understand the point of an Arthur hearing here in Florida. The state bears the burden of proving the case proof evident, presumption great. That's the standard. It's actually higher than beyond a reasonable doubt. That's why the evidence, while I disagree with Brian there, comes into play. The state has an obligation to prove this case to some extent to the judge. And then the issue of bond gets discussed. Because if the evidence isn't sufficient, then the judge has no legal right to hold him no bond. So I believe all these facts should have been discussed. The judge did restrict to some extent what was discussed. And I think that the outcome, while I think high, because $150,000 bond for this type of case under these facts is high, it's within the ballpark of reasonableness and acceptability, in my opinion.
Okay, we're going to continue with our expert analysis. And if you missed it, we're going to listen to more of George Zimmerman as he took the stand today, surprising so many. Bond set for George Zimmerman at $150,000 as he faces that second-degree murder charge in the death of Trayvon Martin. Much more on HLN coming up. Keep it here.
I am sorry for the loss of your son. I did not know how old he was. I thought he was a little bit younger than I am, and I did not know if he was armed or not. Nothing further going.
And I'm sorry, sir, you're not really addressing that to the court. You're doing it here to the victim's family. Is that correct?
They are here in the court, yes.
I understand, but I thought you were going to address Your Honor, Ms. Judge Lester, not. So that's really addressed to the family and where the media happens to be, correct, Mr. Zimmerman?
No, to the mother and the father.
Okay. And tell me, after you committed this crime and you spoke to the police, did you ever make that statement to the police, sir? That you were sorry for what you'd done or they're lost?
No, sir.
You never stated that, did you?
I don't remember what I said. I believe I did say that.
You told that to the police?
In one of the statements, I said that I felt sorry for the family.
You did?
Yes, sir.
So that would be recorded because all those conversations were recorded, right?
Yes, sir.
Okay.
All right, that was George Zimmerman again, starting with an apology to Trayvon Martin's mom and dad, and then continuing with the state's attorney, Bernie Della Rianda, and the state's attorney went on to say, why did it take you so long to apologize? But there, we got a little bit more of what went on with George Zimmerman moments ago. Brian Claypool, as you listen to that again, watch it. I mean, did Zimmerman handle himself well or not?
Well, here's the potential problem, Mike. He has now said under oath that he made these statements to investigators. He's now also said, gee, I didn't know whether Trayvon was armed, right? Well, is that statement also in the recorded interview that he gave shortly after the shooting? If it's not, then that has developed impeachment evidence that the state attorney is going to be able to use at the criminal trial.
Very interesting.
And that's going to be damaging to Mr. Zimmerman if that's the case.
Brian, that's why we have, you guys on here, attorneys who can pick up on those keys like that. Said he felt sorry, said he told that to investigators on the scene. Did he or not? We're going to wait on that. And also, like you said, didn't know if Trayvon was armed or not, yet he shot the 17-year-old. Much more coming up. Keep it here. You're watching HLN.